resources and knowledge, they can.
لو سمحتوا إغلاق المايك بس لو سمحتوا.
So we think that by pooling their resources and knowledge of both institutes, they can leverage their strengths and overcome barriers to innovation. So overall, research collaborations between institutions like the Dubai Judicial Institute can be a powerful tool of driving innovation and development in the UAE. So under the umbrella of the CEO, Dr. Ibtisam Al-Badwawi, we started this cooperation to push the boundaries to a more innovative environment. So by saying this, I would move on.
لو سمحتوا إغلاق المايك لو سمحتوا. تفضلي يا دكتورة.
الدكتورة عبير قفلت الصوت عندها.
وأنا إن شاء الله بتفتح الصوت بس لحظة.
Do you hear me again?
Yes, it's clear. You can start. Thank you.
شكرا جزيلا على information. I will move on. I will introduce to you the Institute for Legal Transformation. I am the director of the Institute for Legal Transformation. And what we do research, review, and reshape the law of the future. So we focus on developing methodologies and research-based solutions for the law which we think should and could be in the future. So we try to identify innovative approaches in the lawmaking process. Therefore, we support governments and public organizations and even law firms in creating legal frameworks for the future they envision, or we think where probably technology or climate change will take us. For this, we have different approaches. On the climate change part, we work with indigenous values, and on the technological part, we work with tech and experts from different parts of technology fields like AI or blockchain. So to my person, I did it here in Arabic. I'm the founder of the Institute for Legal Transformation, alumni of the Max Planck Society for Advancement of Science, and I'm a lecturer at the university, so adjunct professor at the University of Cologne, where I do teach the modern law of Arabic countries at the law faculty under the Institute for International Private Law, as well as I do teach legal transformation as a lecture, as a discipline at the University of Cologne, because we realized we need to work on the challenges we will face now. And if we don't try legally to solve them or be more flexible in order to create solutions for these challenges, we will kind of lose the race with technology. So therefore, we developed the 7 steps for legal transformation where we can support in the lawmaking process. So I will move on about why judiciary as a driver of innovation. So for this, so first of all, why law needs to be innovated and transformed. So you all know last week we had the World Government Summit here in Dubai. I was invited from the World Government Summit or at the World Government Summit to speak about legal transformation, to speak about the importance of legal transformation, to speak about how the law needs to be changed, or how the way of the lawmaking needs to be changed in order to tackle the challenges we are facing regarding technologies, regarding societal change, regarding climate change, regarding many developments and exponential disruption we are facing in these societies. So how should the legal system interact with these changes? So at the World Government Summit, the organizers under Her Highness Hud Rumi organized the whole Regulating the Future Forum. It was all about regulation for the future and facing the challenges legally or in the legal system. So ministers, professors talked about challenges we will face and how the legal system is coming to a point where we can't deal, where we're losing the race, where we're losing the space of regulation towards these technologies. So all these topics were tackled at the World Government Summit in these discussions. So these ideas we talked about at the World Government Summit over 4 days last week with ministers, governmental officials from all over the world, all like agreeing that we need to do something, we need to change, we need to drive the change forward. So, but this is something, but how? This is the main question. How to bring not only change, but innovation, which then serves the people. This is the main question. So this is something I did in my research back then at the UNFCCC. The UNFCCC is the UN Climate Change Secretary. I was there responsible for law and government department under the project Resilience Frontiers. So the idea was, how can we, me as a lawyer and legal researcher, how can we use legal tools and law to be a driver of innovation for the society? How can we use law foresight-driven in order to create the society which can live in harmony together? And during my research, one of the main specific let's say specific actions I could identify was that all over the world there were few judgments which were completely out of the box, court rulings completely out of the box, like in India, where a court gave legal personality to a river, to the Ganges River, or in Germany, where the higher court, constitutional court, gave the right to future generations to be protected by the government. So, and few other court rulings which are not within the law, or what we know how the local law is, where judges completely used their power of interpretation to set a precedent, where they used their power to make a statement, or where used also their power of interpretation to create something new, which is not according the law. So this is something we will tackle in the future, in the next year, definitely. Many topics regarding exponential technologies and climate change. We will work with you, the Institute for Legal Transformation and the Dubai Judicial Institute, on providing you guidance and help and support and insights in how to be part of this innovation and how to use this power of interpretation within the judicial system to be a driver of innovation. So with this said, I would like to now move over to Professor Dr. Ji-Yu Lee. She will now take over the floor and give you a short insight on the interpretation within the court's ruling as a driver or a form of innovation, using different international examples, but focusing on the Chinese courts, which is, I think, very, very important and interesting, because we tend, and especially me in my research, I'm German, I do my research always in Germany, and court rulings always in Germany or Europe or US. But China is nothing we very much look at or we take into account very much, although China is the country which is developing technically or regarding exponential technologies very, very, very fast. And this is very important to see how do they do this? How do they use their judiciary for innovation? But before I give the floor to Professor Ji-Yu Lee, I would like to ask you attendees who are there, please to take notes. Everything I just said, what clicked with you? What do you think? Do you have critics? Do you have an idea? Is there anything you think, I thought about it, or I didn't thought about it, or I read the court's ruling from this country, or I read something about this, and this is what I think. Why? Because after Professor Ji-Yu Lee's lecture, we will move on to a discussion. We will have an open discussion. So I want to know your ideas. I want to know your thoughts. How can we use the judiciary to be a driver of innovation? And then we discuss together, and then we will see, maybe we find an idea, maybe we find a solution, maybe we find a project we can do in order to help you be a driver of innovation, right? So now, please write your ideas down, and then we go into the discussion. So let me now introduce Professor Ji-Yu Lee. Professor Ji-Yu is an associate professor at the University of Durham. Her research finding, just a second. Her research finding have or will be disseminated in internationally respected outlets such as the Columbia Journal of Asian Law, the Cornell International Law Journal, and the Harvard International Law Journal, and have been cited in the Oxford Handbook of Comparative Judicial Behavior and the Expert Handbook of Comparative Administrative Law. She is currently conducting research on judicial studies, a fellowship stipended by at the University of Michigan Law School. So Dr. Lee's teaching and research interests center on public law and comparative law. She writes at the intersection of law and policy, with a particular emphasis on the role of the courts in common law and civil law jurisdictions. So please welcome with me Professor Ji-Yu Lee, who will talk about the interpretation for innovation in the judicial system. Professor Ji-Yu, I give the floor over to you.
Thank you. Thank you, Dr. Haddon, for your kind introduction and insightful opening remark. So let me first share my slide so that everyone can see the slides easily on their ends as well. But it says host disabled participant screen sharing. Could anyone make me a host so that I can share the slides?
Okay, what we can do, I can share the slides because I have your slides. So
okay.
I will share it, okay?
Sure.
Okay.
And I will just let you know when is the next slide. I would like to.
You just
move
tell
on
me
to the next slide.
And then.
Sure.
Okay.
Thank you. That's so helpful.
That's absolutely fine. Okay, but how can I? Slideshow, right? No.
Yeah, it's the updated one
From beginning.
I sent over yesterday.
Yeah. Okay. Good.
Thanks.
Do you see my screen now?
No, not yet.
No. Okay.
Yeah.
Oh, okay, it didn't work. Okay, let me go out. Okay.
الدكتورة بس ثواني الاي تي بيجي حينه.
How can I share this?
Now she can share it.
Now I can share.
She can share it.
She can share it.
Oh.
Dr. Gio, you can share now.
Great. Let me see. Give me a second. Let me open this first. And then let me try share. Great. It works.
I can see it now.
Perfect. Let me just make it full screen. Okay. Can you hear me clearly? Great. Okay, let's get it started. So hi, everyone. It is an honor and a pleasure to meet many legal experts in UAE on this occasion and speak about the role that the judiciary play as a driver for innovation in the law. I have been conducting research on courts and judges for the past 10 years, and I'm really delighted to have this opportunity to share with you some of my key findings in the past, as well as the strategies generated or formulated from these findings. I also would like to give my great gratitude to the Dubai Judicial Institute and the Institute for Legal Transformation for creating this very meaningful avenue and also forward-thinking avenue to connect legal researchers and professionals to prepare and evolve the law for the future. So first, let's start with an important question. Why the law needs to be innovated? Among other things, I listed 3 key reasons for our today's talk and the discussion later, okay? So the first one is related to the development of modern technology, right? In the contemporary world, technological applications and programs have stepped into many aspects of our social lives. For example, the emergence of AI chatbots and self-driving cars and so on. As a result, our legal systems and existing laws are nonetheless facing various challenges brought by the rapid growth in technologies. According to a prediction from the Institute of Electrical and Electronics Engineers, 75% of cars on the road will be autonomous by 2040 around the world. That said, are the current law fully equipped and prepared to handle issues involving self-driving cars? Let's say, when a self-driving car causes an accident on road, who should be held liable? The human driver, the car seller, or the AI developer? In which way can victims claim for damages in an accident? Okay. So the next reason that I would like to touch on is about the ever-changing societal and economic environment. So the types of cases can be shaped and reshaped by the changes in the society, driven by political, economic, and societal events. To deliver justice in individual cases, this important task often falls onto the shoulders of judges who address certain circumstances in cases that are not covered by the existing law and adapt outdated or ambiguous legal tasks in response to societal needs. Okay? So these two reasons are somewhat exposed, which means when some changes happen, we generate strategies, we work on strategies to tackle these changes. On the other hand, there is also an ex-ante approach, which I think is quite relevant or related to the fascinating line of work conducted by Dr. Haiday's Institute of Legal Transformation, which advocates for mindset shifting in lawmaking towards anticipating upcoming disruptions while aiming for envisioned future. These legal futurists are dealing with very important global issues such as climate changes and space law. I'm sure Dr. Haiday will have a lot more to talk about during our discussion, so I will leave the time for you. So now moving on. Discuss the reasons why law needs to be innovated, either because of statutory gaps or the changes imposed by the future. Let me move on to explain why I advocate the role of the judiciary should be emphasized in the development and innovation of law. Okay. First, judges have strong legal expertise and experience. Quoted what a former United States Supreme Court Justice Oliver Holmes said, the life can you hear me? Can you hear me clearly? Okay, great. So judges have great capacities to formulate more responsive legal rules and policies because they're very strong expertise and experience in the law. On top of that, unlike the legislature, courts frequently confront statutory ambiguities or vagueness or legal loopholes that are brought to them by lawyers and the litigants in the form of cases, right? And finally, judgments can indeed function as a vector for judges to gather information about the consequences of a particular innovation in the law and to gauge public support for future legislative amendments. In so doing, courts can actually pilot and experiment on innovative legal policies and signal when the legislature should step in and finalize the legal change. So the creation and adoption of legal policies by courts has been widely studied in common law countries. That's not surprising because the common law tradition embraces this doctrinal precedent, which in theory grants judges and courts. So may I carry on?
Yeah, you okay. Carry on. This like happens by accident. You just carry on, please. Yeah.
Gotcha. Thanks. So this is not actually surprising, right? Because the common law jurisdictions and the common law tradition embraces this doctrinal precedent, which in theory grants judges and courts the authority to create and follow cases with precedential values, which they normally call the precedents, right? These cases, so-called precedents, can serve as a legal basis for future similar cases. However, unlike common law jurisdictions, civil law systems rely on codified statutes and judicial opinions are not recognized as a source of law. Therefore, it is frequently asserted that judges exert more influence over policy making, or let's say the development of law in common law systems than in civil law ones. However, following the significant convergence between common law and civil law systems in the use of prior judicial decisions since the late 20th century, the policies created and adopted by judges started to play an essential role in the development of law in many civil law countries. Okay, this can be dated all the way back to 1896, when the very famous case in France came out. So basically, in this case, a boiler had exploded in a tugboat, which killed the victim, Taifeng, employed by the boat's owner, who are also the boiler's owner. For further investigation, basically discovered the explosion was caused by a manufacturer defect, which means neither Taifeng, the victim, nor the owner of the boat was at fault. It is basically a manufacturing defect, okay? So the dilemma facing the judges at that time was that the French Civil Code established a fault-based system of tort liability with only two exceptions. One exception is to the owner of animals, and the other one is against the owner of the collapsed building. So when those two exceptions happened, they don't really see whether the owner is at fault or not, right? They take tort liability, okay? But in general, it was a fault-based tort liability in France, okay? So clearly, in this case, the owners of the boiler and the owners of the boat do not fall into the scope of the exception, which means the fault-based liability would apply if the court strictly followed the law. The widow of Taifeng would therefore have difficulty getting compensation from the owners of the boat. In fact, the court applied Article 1384(1) of the Civil Code, which may subject a person to liability for the act of things that he has under his guard. Before this case, no other courts had found any basis in this particular article for imposing liability on the guardian of a thing. The Court of Cassation basically shifted the liability of the guardian of any injury-producing things from the traditional fault-based system to a system of risk creation. So once you own this certain item, you kind of create this risk for you to subject to certain tort liability, okay? So this innovation also inspired and persuaded of the French Parliament in a few years to issue France's first workman's compensation law. Move on. Now I will share some recent examples in the Chinese legal system. So what happened in the Chinese law and Chinese courts? So in the following two examples, there are three elements in common. So first, the two examples have an outdated statute. And then there was re-articulation of interpretation by courts at different levels. And finally, a legislative amendment to the statute followed the case decision. Okay. First, let's take a look at our first example. It is related to innovation in DUI cases. DUI cases, so-called driving under influence, okay? So prior to 2009, DUI-related crimes fall within the scope of traffic crime under Article 133 of the Chinese criminal law. From 1998 to 2008, DUI accidents had been increasing in China. There were repeated occurrences of one accident causing multiple deaths and injuries. However, the maximum penalty for DUI offenders remained 7 years in prison. Neither the Chinese legislature nor the Supreme People's Court took quick actions to confront this situation. So facing the serious societal consequences that drunk driver triggered, local court judges started to address their conviction of DUI offenders by applying a different provision in the criminal law, which is called endangering public safety. Okay, so this conviction, this type of crime, may sentence the defendant to death. From these DUI cases decided by local courts, one may observe the struggles that local judges faced in handling DUI cases with serious consequences and the massive experiments on either convictions or sentences run by those judges to test out and form a new legal policy. 10 years after the early DUI case came out, the Supreme People's Court finally issued an official judicial interpretation on DUI crime and selected 2 cases, one from Guangdong province and the other one from Sichuan province, as typical cases to guide future adjudication. Okay. So the second example I would like to talk about regarding this theft crime. So basically, in the second example, judges in China even went beyond the scope of criminal law and warranted ATM thieves a sentence much more lenient than the legally prescribed punishment. It all started from a highly controversial case, first tried in a court from Guangdong province. In this case, defendant Xu Ting intentionally withdrew 170,000 yuan from his bank account, which only had a balance of 170 yuan, after he accidentally discovered the ATM was malfunctioning. So there were basically a few zeros added to his bank account balance. So he was sentenced to life imprisonment for violating the statutory provision that are provided on the slide, section 1 of article 264 of the criminal law by the intermediate court at the first instance. So after this decision came out, debates as to how to define financial institutions and how much money should qualify extraordinarily large amounts were boosted in China. Experienced 5 instances at 3 different courts, Xu Ting's sentence was eventually reduced to 5 years in prison. So from life imprisonment to 5 years in prison. Okay, so the influence of Xu Ting case extended straight away to courts from other jurisdictions. A similar case decided by a sister court in Yunnan province in China even reversed its effective decision based on the Xu Ting case. Another similar case in Zhejiang, filed right before Xu Ting case, was intentionally remanded to the Public Security Office twice for additional investigation, just to wait for the final decision of Xu Ting case to come out. So those 2 cases were even labeled by the media as Xu Ting of Yunnan and Xu Ting of Zhejiang, respectively. In February 2011, an amendment finally came out to remove Section 1 and Section 2 from Article 264 of the criminal law, which prescribed a quite harsh, a quite heavy punishment for 2 types of theft cases. So a criminal law amendment came out in response to the court's innovation. Okay, so the new legal doctrines basically established by these Chinese courts, following the popular computerization of cars and ATMs in China since the 1990s demonstrate a bottom-up lawmaking process that starts in local courts and moves all the way up to the Supreme Court and even to the legislature. Taking a closer examination among these case decisions, one may find that the subsequent courts silently adopted early court decisions by including very similar statements or considering factors in their own judgments. So drawn from these examples, where judges found their ways to make policy and contribute to the innovations in the law through adjudication, I would like to summarize some main approaches that can be adopted, that can be adopted or undertaken by judges in both common law and civil law jurisdictions for legal innovation. Let's start with the situation in the common law system. So when interpreting unclear or outdated statutes, common law judges may rely on various statutory construction tools and doctrines, such as mischief rule, where judges analyze or examine the mischief or the wrong which a statute amendment aimed to correct. American courts also have disregarded the plain meanings of statutes to avoid a legal conclusion they would otherwise find absurd. Such judicial ideology is also reflected in the commentaries on the Laws of England by Blackstone. A quick example would be this case I listed here, Riggs versus Palmer, which was a famous New York case decided in 1889. In this case, Francis Palmer created a will dividing his estate among his two daughters and his grandson, Elmer Palmer. So Elmer knew the term of the will. In 1882, Elmer murdered his grandfather by poisoning him to basically expedite his way to get the estate sooner. Elmer was convicted of murder and began serving his sentence. The plaintiffs sued to annul the parts of the will under which Elmer inherited, alleging that Elmer's crime rendered his inheritance void. So the court basically ruled in favor of the plaintiff. The court held that when enforcement of a statute renders an absurd or unreasonable result, a court may interpret the statute in a manner which displays the lawmaker's true intention. So that means the court can occasionally go beyond the plain language to interpret the statutes in a way that it wouldn't create this absurd results, okay? So the court also held that the legislature could not be reasonably expected to address all contingencies in crafting law, and that had the legislature reason to suspect one might behave in the manner that Elmer did, they would certainly have addressed that situation, okay? So as you know, there is also a long-standing doctrine, there's also a long-standing doctrine of stare decisis in common law jurisdictions, that is, judges should follow higher court decisions as binding and consider sister court decision as persuasive. Under the doctrine of stare decisis, common law judges nevertheless managed to depart from precedent through a tactic, which is often called factual distinguishing. So before explaining this tactic, I think we probably need to look at the two kind of essential concepts. One is, one is ratio distendi, and the other one is obiter dicta. So in common law precedents, there are ratio distendi, which are statements of law based on the key facts they are binding for future adjudication of similar cases. However, a judge may still refer to a number of matters in their judgment that do not directly relate to the key facts as established in the case. These matters are called obiter dicta, which means things that said by judges, by the way, or in passing. Obiter dicta may have persuasive force instead of the binding force, but obiter dicta will not bind on lower courts, unlike the ratio decidendi. Because who decides which is ratio decidendi and which is obiter dicta in a precedent are always the judge in the subsequent cases. These judges are often able to distinguish a precedent from a present case by claiming the case at issue has different key facts. This tactic, therefore, is called factual distinguishing. Okay. So now let's look at the civil law situation. As we previously discussed, despite the absence of an official case law system, civil law judges.
Do you hear me?
Yeah.
Okay, just because we lost so much time before we could start, so we are very short in time now, and I would love to ask you to kind of wrap up or like very soon, so we can start with the discussion, and the attendees can ask you then questions. I think because we have not much more time left, just 30 minutes. So would love to ask you so we can move on to the discussion.
Sure, thank you so much. I'll do that. Can I still have like 3 minutes to wrap up? May I still have 3 minutes to wrap up?
For sure.
Okay, thank you. Because I do really want to like touch on the civil law jurisdiction.
Civil law jurisdiction is very important because it is also the jurisdiction of the UAE here. So
absolutely. So that's why I want to touch on that. So I will make it really quick. Okay. So basically, as we previously discussed, there is like, traditionally no official case law system. So basically civil law, however, civil law judges still played a role in legal innovation. So, but how? Basically to help an innovative legal idea to be adopted by other judges and then reach a national consensus for legislative amendment, judges need to know what the earlier judges did in their judgment. Therefore, judges in civil law jurisdictions collectively innovated law also through this publication and transmission of decided cases. Okay, so because of the time limit, I'm gonna only give an example for the France. So basically in France, Court of Cassation, the highest level of French courts, issues and imposes its interpretation of law, which is called the de la jurisdiction, as de facto binding authority for lower courts. It also publishes its annual report as an important instrument for jurisprudential innovation. In Germany, there is also kind of like a working case law system happening. And some cases, when courts publish some cases, it also accompanied by what is called head notes. With those case decisions, these head notes often contain the general rule which have been developed in applying the law and which are regarded as applicable to similar cases. Okay, so of course, in Japan, there is also this case law system developed recently, and also Japanese judges sometimes will interpret the statutes in light of sense of society to make innovative interpretation. Of course, in China, happy to discuss this more in our later discussion. Basically, we have the same similar quasi case law system developed recent year. Okay, so next approach, possible approach is basically facing this advent or development of modern technology and global globalization of financial market. A few countries also innovated and experimented on setting up certain specialized courts or train a group of specialized experts to handle complex cases and novel cases. Okay, so here I have some examples in Germany, UK, and China. Happy to talk about later. And also their benefits, right? So basically, quality of judgment because they are better trained, greater resources because they have higher concentration on certain type of cases. Blah, blah, blah. I'm gonna really quick wrap this up. So basically, based on interview, I interviewed with an IP lawyer who talked about the Shanghai IP court. He basically mentioned that there's also a group effect of those elite judge, those like specialized experts, which basically have this group effect. When they have a group of people together, they can constantly talk about cases, which he said will only make things better. Okay. And also finally, involving experts and academics, which we are already doing, which is very promising for today's occasion and workshop. So basically, before long time ago, traditionally people think academic opinions might not be really relevant for the practical judgments or legal practice, but actually empirical research has found for example, from 1949 to 2009, 32% of the US Supreme Court's decisions cited law review articles. This is just like academic work and also international, sorry, there's a typo. International criminal courts also cited academic work. And also, interestingly, what I found is that Chinese law firms sometimes regularly invited university professors to help them prepare this expert opinion when they try to submit their memo or certain document to court when they dealing with controversial or novel cases, especially in cases with a lot of technical complexity. Okay, again, participation of subject experts in court. Some courts, for example, Shanghai Financial Court recently set up this international consulting expert panel to involve academics and subject experts to the panel to discuss novel cases and novel issues. And then there's also long history of involvement of expert witnesses who can provide scientific ideas to the trial hearing. Moving on, finally, the key takeaway. Let me just say a few things about key takeaway, and then I will give the floor back to our audience and Dr. Haidat. So basically, to conclude, I would say, like common law judges from civil law jurisdictions, well, in theory, strictly bounded by written statutes, can nonetheless innovate the law through their artful statutory interpretation. And based on today's discussion, I would like to put forward 3 potential approaches for judges or court to consider to innovate the law or collectively participating in the development of law for the future. Okay, so those approaches include interpreting within or beyond the legal task for justice, forming a group of specialized judges for complex cases or technical cases, and incorporating subject experts and academic opinions. Okay, so I also would like to end my talk by a quote from Michael Zander from his seminal book, which is called The Judicial Lawmaking Process. So he basically said in his book, when a judge decides a point of law, he's declaring what he finds the law on that point to be. In giving voice to his opinion as to what the law is, he may have added something new to the existing corpus of the law. From the judge's point of view, the judge's function is to declare the law. From the point of view of the observer, he may, in declaring the law, have added something new or even changed the law. Okay. Thank you for your time and attention. Happy to hear your thoughts and questions, and yeah, appreciate it.
Thank you very much, Professor Dr. Jiu Lee, for your insights, for your description, the differences between the common law and the civil law, examples you named on how, for example, in French law, the judges inspired the France Parliament to change then the law, or in other cases in China where the lower courts inspired the higher courts, and then the government followed the court's innovation which started in the local courts. This I very much not only liked, but also it was like showing us what is possible from the history. So back to my to our audience who are attending here. So we go now into the discussion. What Professor Dr. Jiu Lee explained to us as part of her research, showed us the history of how judges and judiciary can use this part of interpretation or interpretational room, let's say, or space for innovation. But this is history. So for us, especially for the Institute for Legal Transformation and for the Dubai Judicial Institute, it's very important to think about how can we use this room or this space of interpretation for the future. What if we know what judges and judicial system, prosecutors, lawyers gonna face in the future? For example, Professor Jiu asked, what about use of AI-driven cars or like independent autonomous cars? What about the liability? So the judges will be the first ones who will face this question because we don't have laws. So as soon as self-driving autonomous cars will drive in the street, we will have this problem. We do already have in some parts of the US. So judges will be the first ones facing this challenge. What about assets on a blockchain? We had a lecture on blockchain last year in June. What about assets stored on a blockchain? This is something also we will do later. What about crimes in the metaverse? We will have for you with the Dubai Judicial Institute also a mock trial and experience in the metaverse and about criminal crimes, about crimes in the metaverse. So how should we deal then with that? What about drones? Drones are like coming more and more adopted by society. What about drones if something happens, an accident happens, a drone and a person? If a drone, for example, is controlled by an AI? And for example, what about intellectual property? If an AI produces a picture, but using open source information, but the person just gave in the information, what about the intellectual property? These things are already happening. These things are already adopted by society. So these things will sooner or later face the judicial system. And there where we need this mindset of innovation, the space of interpretation in order to be able to interpret in the right way and to get solutions as we then, as Professor Dr. Jiu showed us, then inspire the legislators to create laws. As she said, for example, in Germany, we do know the Richterrecht, we call it Richterrecht, which is the case law, which is the de facto lawmaking by judges. Judges can make law, which will be then put into law 5 or 10 years later, but it is used by other judges or by other courts only because it's out there, because it's a precedent. So it's new. So the first ones who rule or who have a court decision are those who are gonna kind of guide the others. So I want to open the floor now with these questions to you Do you see any common ground with the UAE, with the work you do? Do you already face any of these challenges, or do you think about any of these challenges and you think, how can we be innovative, or do you have any ideas to share? I would love to open the floor for everyone. Please just raise your hands. Just raise your hands if you want to say something. And please take the floor and ask your questions.
إذا
So is anyone have any questions to Professor Giu, or any thoughts to share? You can ask in Arabic and it will be translated in English. So till, let's say, someone asks a question, I would, okay, Mushair Mohammed, Mr. Mushair Mohammed, please take, should I unmute you? Okay.
السلام عليكم ورحمة الله وبركاته. شكرا جزيلا للمحاضرة القيمة، وأنا أفتكر أن المحاضرة دي تعتبر محاضرة قيمة جدا لأنها بتطرق مواضيع في غاية الأهمية بالنسبة للتطورات التي تشهدها الساحة القضائية بشكل عام في كل العالم. نتيجة التطورات اللي بيشهدها العالم، نحن أمام تشريعات، أمام أحداث جديدة، أمام معطيات جديدة. لا بد أن التشريعات تواكب هذه المعطيات والأحداث بشكل يعطي القضاء القدرة على أخذ قرارات صائبة وقرارات مفيدة، لأنه هذه القرارات ستكون هي الأساس الذي ستقوم عليه التشريعات القضائية لاحقا. كثيرا ما خطر في بالي ماذا سيكون التشريع القضائي، وهل سيكون متناسب مع ما تشهده الساحة من أحداث جديدة بالنسبة للبلوك تشين، بالنسبة للدرون، بالنسبة للتجارة الإلكترونية. كل هذه الأشياء تحتاج مننا إلى ابتكار وإلى اكتشافات جديدة وإلى قدرة على الخلق والإبداع، وقدرة على إنه كيف إنه نحن نقدر نوازن ما بين المعطيات وما بين مقدرة القضاء على تحليل الأشياء ووضع قانون. أفتكر قانون الواقع سيكون مرحب به، لأنه هناك بعض الأحداث تختلف، لا بد أن يكون للقاضي رؤية ولا بد أن يكون للقاضي مقدرة على اتخاذ القرار الصائب. نحن أمام اكتشافات كثيرة، لا بد أن نكون حضور كقضاة وكمحامين وكعاملين في المجال القانوني. لابد أن نكون جاهزين لهذه الطفرة التكنولوجية، وأتمنى أنه يكون في محاضرات كثيرة في هذا الصدد عشان نستفيد منها ونقدر نخرج منها بالمفيد. شكرا جزيلا ثاني للمحاضرة القيمة.
شكرا جزيلا لك. اللي قلتي دا احكي بالعربي، اللي قلتيه كثير مهم، واحنا راح نكتبه على مود نستفاد من عنده للمستقبل. فاذا عندكم اي افكار تقولون انه احنا نحتاجها على مود نسوي نبتكر اكثر، نتعامل مع اللي المشاكل او التشالنجز اللي تجي علينا احسن، please feel free. يعني ادعوكم انه تناقشون هاي المواضيع هنا، هذا المكان اللي تقدرون تناقشون به افكاركم على مود نستفاد من عنده ونسوي لكم تدريب او تريننج احسن اللي يخليكم مثل ما قلتي مستعدين للابتكار. تفضل مستر أحمد.
شكرا جزيلا دكتورة، الله يعطيكم العافية جميعا. طبعا ليس بعيدا عما تناولته الأخت قبل قليل، ولكن الآن في تحديات كبيرة في عملية التحول الرقمي في المنظومة القضائية، واتجاه نحو العالم الافتراضي أكثر وأكثر في الفترة القادمة. ويضم ذلك مثل ما تفضلت الميتافيرس، وأيضا البلوك تشين والتطبيقات الاي اي المختلفة اللي ستكون موجودة. اليوم التدريب القضائي هو ليس فقط تدريب نظري، إنما هو عبارة عن كومبينيشن، سترونج كومبينيشن ما بين البراكتيكال ابلكيشنز اللي موجوده وما بين التدريب النظري، وانك كيف تستطيع ان تعمل هذا الكوهيرنت يعني نقدر كومبينيشن بتوين ذم. السؤال اللي احب اطرحه ويا ريت احصل على جواب، ما هو التصور لكيفيه طرح هذه المساقات التدريبيه في المستقبل؟ اليوم التدريب جدا مهم بالنسبه للمنظومه القضائيه، وذلك للحاجه اليه من حيث تجويد المخرجات، من حيث النقل المستوى المهارات والكفايات لدى المتدربين. لما اتكلم المتدربين اقصد الجميع، يعني حتى القضاة، حتى سعادة القضاة والمستشارين وغيرهم، وايضا كذلك المحامين مختلف سواء كانت الجانب القضائي او القانوني. كيف يتم او ما هو التصور لطرح مساقات تدريبيه لهذه المواضيع في المستقبل؟ ما هي الآلية
topics in the future? What is the
وكيف
mechanism?
يتم عملية
And how
التطوير العملي
can we
كذلك؟
develop on practical work and practical training in this regard? Thank you.
شكرا جزيلا.
Thank you very much.
تريدني أني أجاوب على هذا السؤال؟
أي تفضلي، سواء كان أنت أو الأخوات الموجودات.
خليني أني أعطي جواب صغير أو إذا أحد ما أحد دبي القضائي يريد ياخذ الفلور يجاوب. هم بالعكس السؤال كلش حلو. And I'm sorry, should I talk in English or in Arabic for the
Feel free.
لا أنا مترجمة عم توصلكم بطريقة صحيحة عمود ما المترجم ما يتأذى. So I will stick to English. It's I think better. First of all, I can say you are here at the absolutely right place, because the Dubai Judicial Institute is, as far as I know, the most advanced when it comes to future challenges, to tackling future challenges. And I have to see it, the CEO of the Dubai Judicial Institute, Dr. Abtisam al-Badwawi, for her, this topic is very important because the UAE itself is working on creating the future. The UAE itself as a country whole is pushing the boundaries when it comes to technology, is pushing the fourth revolution, which is the revolution of digital transformation, let's say the digital transformation. So UAE is pushing, that's why all governmental entities need to be prepared, which includes also the legal system and includes also the judicial system. So that's why we at the Institute for Legal Transformation are invited to cooperate, or we do cooperate with the Dubai Judicial Institute, exactly because of this reason, because we tackle the challenges the legal system is going to face in the future. So this is my first answer, because I do not know many training centers in the legal field who do really take this innovative and transformational approach like the Dubai Judicial Institute. This is first said, so you're absolutely in the right place. Second is, what are the you asked, what are the training possibilities, right? Judges and legal professionals will need to deal with these future challenges. And I see Dr. Jiu Lee just answered the question, so I would rather read hers. So she answered to you. To Jiu, do you mean Adham or Ahmed? Ahmed and Ahmed. She said, Oh no, this is another question, sorry. So what I would say is first is working on the mindset with the judges and legal professionals. So what we do at the Institute for Legal Transformation, we also work with the, for example, in Pakistan, higher courts judges who want to kind of push the envelope to be ready for the challenges. So we work on the mindset change. We introduce the technologies which are coming, the challenges which are coming. So for the next year at the Dubai Judicial Institute, we will have courts, we will have mock trials in the metaverse. We will explain to you criminal acts with blockchain, with crypto, and we will discuss all this so you have a sense of understanding what is out there. We will tackle also AI and the challenges AI brings with it. So we want to educate the legal professionals more than just what they already know and what they already taught in universities, but more as the new challenges which are coming towards them. So if they understand this, they are more flexible to deliver innovative solutions. I hope I answered your question. If not, then please feel free to send me an email anytime and I will answer all your questions.
Thank you very much, Dr. Amir. Thanks a lot.
Okay, so who's next? I think Ustad Ahmed Babikar, Dr. Ahmed Babikar. تفضل. Yes? You're mute still.
السلام عليكم.
وعليكم السلام.
أنا شاكر جدا ومقدر لهذه المحاضرة، شكرا جزيلا. بقول يعني هي فعلا التحديات باتت أمامنا يعني واضحة جدا وبكثرة، يعني هي ما مثلا نقول يعني حاجة استثنائية، هي أصبحت حاجة واقع. فأنا بقول يعني كحاجة عملية ممكن أصبح التعاون يكون أكبر مما كان، يعني فيكون مثلا نحن في حوجة إنه القضاء يتعاون أكثر مع مثلا يعني في وزارة الاتصالات أو يعني الوزارات المعنية أو المؤسسات المعنية بالضبط. يعني في مجال الزراعة ممكن هي تتعاون مع وزارة الزراعة، بالمقابل لازم تكون وزارة الاتصالات موجودة في هذا الصدد. الشيء الثاني اللي أحب أذكره هو يعني مثلا نحن الحين عندنا التطبيقات هذه، يعني معظم التطبيقات هي بتقول لك مثلا هو يعني عنده الكوكيز، إذا أنت ما موافق هو ممكن يقول لك خلاص أنت ما بتقدر تستخدم تطبيقي هذا. وإذا وافقت أنت ممكن تكون ما قريت الشروط وبتدخل غالبا ما بتقرأ الشروط، بتوافق عليها وما معروف اللي يصير بعد. فأنا من هنا بقول يعني مثلا كخطوة أولى ممكن الدولة أو الحكومات هي اللي ممكن تقدر تتحكم أكثر. يعني مثلا أي حدا عنده تطبيق، عنده شيء ممكن لازم يسجل في وزارة الاتصالات، عنده مثلا كذا، دي هي كخطوة أولى. لكن هو الموضوع جدا متشعب وكبير، فأتمنى لكم التوفيق وإن شاء الله ربنا يكرمكم، وشكرا جزيلا.
شكرا جزيلا أستاذ أحمد، خاصة أنه جبت سيرة الزراعة، أنه أحول الإنجليزي. What you referred to is something very specific, which is, I go back to what Professor Dr. Giu said, is like in specific fields, it's better to have experts and to work with experts from this field to help you in order to, because the world is getting more and more complex. It's getting more and more complicated, and especially when it comes to technology, we are not able to solve or to understand everything very easily. That's why it's good to have experts, and I think I just reminded me of what you just said. I just want to read Professor Dr. Jiu's answer to a question. Allow me, please, Professor Jiu, to read your answer to Edham. Is it okay? Okay, Mr. Edham asked a question previously, which is,
yeah, absolutely.
Please, okay. He asked, could you please elaborate on the role of the Supreme Courts as well as judicial activism encouraging legal innovation? So you can just say your answer again. Yeah.
Yeah,
please.
thank you so much. Yeah, so we do. I'm very pleased and happy to see so many very insightful questions from our audience, because I mean, of course, this is a very informed audience today, and we have legal experts in UAE, which is really great. So I mean, to respond to this question, basically, I would say, yes, there is definitely an interplay or collaborative relationship that can be formed between national high courts and the local courts, right? So for example, in China, the Supreme People's Court in China may either issue judicial interpretations, which is kind of quasi-legislation, even in the absence of cases or controversy. They could just like identify certain issues based on adjudication experience from lower courts and issue this abstract policies, which is called the judicial interpretation, which is a normative document that lower courts can follow in the future. And the Supreme People's Court, what they do also is to select and publish certain local judgments as typical cases or guiding cases for future courts to refer to when judging similar cases. So what I would like to add, just a few words, is that when we talk about legal innovation or innovation in law, it's quite important that we recognize there is a tension, there is a balance that we need to look at, is the tension between consistency of law, predictability of law, and the innovation in the law, right? So that's why we need a publication, or we need availability of decided cases as much as possible for future judges to follow. And we need more training, more meaningful training like this to help legal professionals to develop, or future judges develop, a consistent and a standardized practice to follow legal innovation, innovative decisions, and to gauge a way forward, right? Otherwise, if we open too much a door, then there might be inconsistent judgment across regions, right? So we want to have this balance between consistency of law and innovation in the law. Thank you.
Thank you very much.
Back to our audience.
Thank you very much. Did you saw the other question from Mr. Edham, who asked, if you delayed, one more question he had, would you recommend any published decisions in landmark cases in China or else that could be viewed as good samples for well-articulated legal innovation through interpretation? Very good question. Maybe
Yeah,
this is something you can share via email also.
Absolutely, absolutely. So this is actually a very interesting question. So basically, what I would recommend is not only like one case. I mean, the landmark cases I would recommend are called guiding cases. In Chinese, is called 指导性案例. So these guiding cases, basically this Chinese Supreme People's Court started to publish those guiding cases in print and online to guide the future adjudication, also require lower court judges from all regions in the country to follow or refer to these cases when adjudicating similar cases. And right now is about 200 of these guiding cases, and they cover a wide range of different types of cases, civil cases, criminal cases, administrative cases. And very importantly, right, those guiding case have the section called key point of adjudication. It's very similar to the racial disadvantage, but it is not really, right? But those key point of adjudication is normally what lower judges and lower court judges or future judges particularly look at when they handling similar cases, because those kind of like a rule of law established by each guiding case.
Amazing. Thank you very
Terrific
much.
Question. Thank you.
We had other questions also in the line, but I think we're coming to an end. And I have one more question. It's a direct message to me, which is, I read in Arabic, هل الأحكام القضائية القابلة للتطبيق في دولة تصلح للتطبيق في دولة أخرى? Which is, are the judgments or court's ruling in one country, are they applicable or transferable in another country? This is the question, especially when it's very innovative and out of the frame which the local law gives, right? I give to you.
Oh, thank you. Yeah. Thank you for translating this question. This is a terrific question to end this workshop today, I feel. So thank you for asking it. So basically, I would say this is quite relevant because it talks about how to adapt international principles or foreign judgments to the local situation or to the local jurisdiction, right? Because we might have like different legal culture or different local customs or different types of legal sources that identify as official legal basis in the cases, right? But I would say I'm quite positive about incorporating certain foreign judgments or foreign landmark cases to from a foreign jurisdiction to a jurisdiction that is also ongoing similar things. That's why we have this long history of legal transplantation, right? That's how innovative legal ideas or concepts travel across jurisdiction. That's why we need a more international and globalized community to help us assist this process and make foreign ideas or foreign precedents more transferable in the local jurisdiction. So give you just a quick example. In Shanghai Financial Court, they have a team of legal experts and a translation team to basically identify some landmark cases in foreign jurisdictions and translate them into Chinese to keep their judges informed of what is happening in other jurisdictions. Because what we are talking about today, AI-generated work, self-driving car, or climate changes, those are not local issues. Those are global issues. Those are like the issues facing the modern society in all different countries. So that's why I think creating this kind of avenue for judges to communicate together is very important, because those are the frontline experts who deal with new situations by their day-to-day adjudication works. Thank you.
Thank you very much. And you pointed a very, very important you pointed out very, very important aspect, and I would love everyone to hear that right now. You just said these challenges we can't tackle locally. Artificial intelligence is nothing which fits into the box of the UAE law or the Omani law or the German law. Artificial intelligence, there are companies sitting in the US, in China, in Singapore, in Africa. Blockchain is decentralized. It is stored on different computers all over the world. So if you change your law in one particular country, they just move on. It's borderless. This is the problem. That's why the international approach is very, very important. And that's why learning from other international court rulings is very important, because these things are beyond national jurisdiction, are beyond national implementation, right? So this is a very good question, and this would be like my add-on to you. And we have so many questions. This is amazing. So there's another question from Yusuf El Khadrawi, which is written in the chat. He said, or like maybe it's a comment, artificial intelligence must be present in court sessions and the use of similar cases recorded in the past. And the legislator must open the way for the judiciary to amend and keep abreast of the rapid development taking place in the world. I love this statement. Would you, Professor Dr. Jiu, would add something to that?
Yeah, I think I cannot agree with the statement more, right? The use of decided cases are very important, especially for you know, the continuance of legal innovations by various stakeholders and the legal actors, right? That's first of all. And also another thing, like for the emergence and assistance of artificial intelligence powered applications and programs are existing in different jurisdictions, and they are kind of like help us update our legal concepts or help us generate those past cases in a more efficient way. But again, I would say, you know, at this moment, I would say still the initiatives taken by our human judges or human lawyers are really, really important and essential as drivers to drive legal innovations, because artificial intelligence or machines kind of have this backward thinking, right? They interpret and analyze law in the past, cases in the past, but lawyers, judges, and our legal expert today, we innovate, we evolve for the future.
Absolutely. I love what you just said. We should not rely too much on artificial intelligence. Why? Again, if you understand the technology, you know what's the problem behind it, because artificial intelligence is just trained with the data we gave to it or we feed in, which is just representing the past. Artificial intelligence, if it, at least language processing models, till now, they need to be very advanced so they can create regulation or decisions, creative decisions for the future, which it will be for sure. But for now, the human creativity, the human solution finding is still very, very important. So just to add on this, we at the Institute for Legal Transformation, we work with researchers from Italy and Germany from the Max Planck Association. We work together on creating language processing models, which would be AI, common used as called as AI for creating legal solutions. But specifically, like this is something we really work on, because we think if we feed the AI in the right way with our comparative law methodology, we can create really usable AI for specific fields in law. So maybe this is also interesting for judges. By the way, judges in Colombia already are using ChatGPT for drafting their court rulings. So AI is getting more and more into the courtroom even. So, but the problem is you need to know how to use it. Otherwise you will get wrong answers. So my question would be to the audience, would you like to have a course or a training on ChatGPT and how to use it for your court rulings? Why not? Like in Colombia or Costa Rica, it's used also. So there's also another statement from Adham Hashish, which is, thank you very much, Dr. Abir, for your insights, and Dr. Lee for your informative presentation. I hope the recording will be available on YouTube, as we need to share it with our students. So to the organizers, Mariam or Haifa, I hope the recording can be shared so people can share it with their students. I think now, is there any more questions? Otherwise, I would like to kind of end the session. So, yeah, okay. I just saw. Thanks again for all the food for thought. It will be great to share it with our students in the UAE University. Also, training will be a perfect idea. You mean training with JetGPT, Ustad Adham? Yes, actually I do, as I said at the beginning, I do teach at the University of Cologne in the law faculty. So law students actually in the end, short before the examination. And I use JetGPT as a training and education tool. We use, and I train my law students how to deal with JetGPT and how to use it and how to identify. This is more important, how to identify as a human, where are the pitfalls, how to say, where are the problems, to be very critical, because we can't just let them use it and not guide them. This technology will take over. This technology will rapidly change the way we work, even in the legal field. So what we should do as educators, we should give them guidance, the students, or also not only the law students, but also who are already practicing and are new to these technology, to give them guidance on how to use this technology and how to use JetGPT, and knowing the dangerous side or the danger behind it. So I would go give over to last two questions. To critically use it. This is something I really do with my students within my normal lectures, and within legal transformation is all about that. Technology, fine, but we need to step up, to be ahead, and that's why we need the mindset. I take only these two questions and then we close the sessions. I see it's very heated. Amazing. تفضل Mr. Ashraf Qasim. And then Mr. Abdullah, and I think we close then the session.
نعم، يعني أشكر لكم وقتكم وهذه المادة الدسمة التي لا شك أن استفدنا منها. في الحقيقة عندي مشاركة بأن لا شك أن مواجهة التحديثات اليومية المتسارعة الحياتية وخاصة منها التكنولوجية هو أمر جيد أن نجد له حلا مهما في القانون، ولكن ونجد له صدى في تصدي القضاء، إلا أن ذلك يعني يصطدم بتحدي كبير، وهو أن كافة الدول وفي القلب منها ما يهمنا في كوننا نعيش على أرضها دولة الإمارات، وإن كانت متسارعة في إيجاد البدائل لكافة المستجدات، إلا أن المحافظة على الموروثات القضائية والقانونية هو أمر مهم للغاية لكافة الدول، ليست للإمارات فقط، ولكن أن نحافظ على هذا التراث وهذا الإرث من الأمور القضائية اليومية هو أمر جيد للرجوع فيه مستقبلا في كافة القضايا المتشابهة. ولذلك يتبادر إلى ذهني سؤال، وهو كيفية الموازنة ما بين مواجهة هذه التحديثات وفي ذات الوقت المحافظة على هذا الإرث القضائي القانوني المهم لا شك. يعني هذا هو سؤالي، وأشكر لكم حرصكم على الإجابة. شكرا لكم.
Was it translated for you, Gio? Professor Gio? Professor Gio, do you hear me?
Oh, let me unmute it. So yeah, I don't think this has been translated for me. Could you summarize this in English? Sorry about that.
It was let me try to summarize it. Mr. Ashraf, please
ادخل شوف لي الطلبات. اوكي، بس طلب قديم مو الحين. ان نحن قدمنا بخصوص مبلغ كان من استقطاع راتبه 200 وشيء.
Can someone بس تسكرين المايك؟
مش من الطرف الثاني، منا نحن طلبات مقدمة.
Can you please just mute this person? Okay, Mr. Ashraf, you said that we live on the ground of the UAE, right? And we need to keep the tradition of court rulings. Am I right? Or can you again just summarize it so I translate it in English?
Excuse me.
تمام، يعني أنا أشكر لكم شكرا على المشاركة مرة أخرى. أنا أتحدث عن أنه لا شك في أن مواكبة التحديثات ومواكبة الأمور الحياتية المستجدة المتسارعة اليومية أمر جيد أن نجد له صدى في الأحكام القضائية وفي تصدي المحاكم لها، إلا أن قد يتعارض ذلك مع الموروث القضائي الموجود لدينا، وهو أمر مهم للغاية أيضا أن نحافظ عليه وأن يكون إرثا ذات قيمة. وبالتالي السؤال كيف نوازن ما بين هذه التحديثات وهذه المستجدات الحياتية اليومية وما بين المحافظة على هذا الإرث القضائي القانوني الموجود لدينا.
Okay, perfect. Hissa, I think I will translate in English. I mean, what Mr. Ashraf just said is okay, innovation is nice, kind of, and it's coming towards it, but still we have a history and still we have a tradition, a legal tradition. And I think what he refers to is what you, Professor Jiu, mentioned in advance, which is the consistency of law and the innovation of law. So this this challenge you mentioned before how to value both and how to tackle both. Am I right, Mr. Ashraf? Yeah. I think
thank you. So thank you for the question. This is very, very insightful, also important. Okay, so basically, as Dr. Haidar just mentioned, right, there is a tension between consistency of law and innovation in law. When should we do innovate and to what extent? That's always a question that for legal professionals to handle, especially in novel and controversial cases, right? So I would say, I completely agree with you. There are long history of legal culture, there are long history of existing law, and we want to make sure law is predictable for people who are involved in legal disputes. But on the other hand, legal innovations are not only triggered or driven by judges, but judges one-side initiatives. It could also driven by lawyers' opinions, by litigants' challenges about legal loophole in their cases. So it's not like judges would always like actively or proactively look at those legal loopholes. It's more about we have this reliable legal process, judicial proceeding to for us to rely on or for us to work with and work within to innovate or preserve the consistency of law. And on top of that, there are also internal and external constraints about how much judges can innovate, right? Because, for example, internal constraints could be the internal promotion for individual judges, right? Who gonna review the performance of judges and who gonna see whether this case decisions has been innovated in a very positive way, or hasn't this decision kind of in contrary to the consistency in law. And also the external constraints could be the appeal process, right? When the litigants see, okay, this decision has been innovated or has been departing from the past decisions or law too much, they will challenge the certain decision and let the appeal court to reverse certain decision or to refine or to sustain the certain decision judged by lower courts. So I would say, these are valid concerns, but we do have a legal system and judicial proceeding that we
see you. You're mute.
Oh, I'm mute.
Okay, no. It was just like the few last seconds. All good.
Okay.
All good.
Yeah.
You heard everything. All good.
Okay, great. The first and last sentence was just say, Oh, I think these concerns are very valid, and these concerns are clearly from legal expert who dealing with cases on routine basis. So I do agree with you on this end, but on the other hand, I do think we have a reliable functional, as long as we have a functional legal system and a judicial proceeding to work on or work within, these innovation or the innovation taken too far a step will be remedied or reversed through the appeal process or different type of strategies or follow-on procedures to address. So I do think there is a functional system that can balance the legal consistency and legal innovation, as long as we have this awareness and consciousness about the potential tension. Thank you.
This is absolutely amazing what you just said, and I need to say here at the Dubai Judicial Institute, this is the case. The traditional, or like what we need, the consistency of law and rule courts. Decision making, let's say it's going on, the training is amazing, and as an add-on, the institute comes in, the Institute for Legal Transformation, which is only focusing on this part of future readiness. It doesn't mean that you do only this or that, but we need both meanwhile, and if you are aware of the challenge, then the chances are higher that you can keep the balance. Otherwise, you will just lose track of technology. So last question. We need really to come to an end. I'm so sorry. Mr. Abdullah, just ask your question, please, and we will try to answer it quite fast so we can end the session. Thank you very much. Take over the floor, please, Mr. Abdullah. Ms. Abdullah, you were raising your hand. Was it by accident? Or maybe your question was already answered. So we have just one last question from Mohammed. Any current experience in China or Germany for AI, I think, AI, to provide the public a legal service, whether from law firm and courts? I'm not sure if I'm understanding the question right. If there is any experience, public a legal service, whether from law firm or court, do you mean regulation? The EU, I mean, in Germany, we don't regulate on a local level. It's more EU guidelines, which European Union guidelines, and there are guidelines in the making, drafted from last year, May, regarding artificial intelligence and regulation of artificial intelligence, but it's only focusing on liability questions when it comes to artificial intelligence, because this is, let's say, the most urgent, and this is what comes before civil courts, but we don't have courts decisions yet. We don't have courts decisions yet in Germany. As far as I know, it's there are courts cases, open cases with Teslas, Tesla's self-driving cars. They are in the US already, but in Germany not yet, and we do not have regulation to cover this topic. I don't know about China. I think this question you can ask Professor Dr. Jiu Extra, Mr. Mohammed, happy to provide her email address. And I would like to close this session. Unfortunately, even the discussion is so amazing, and I think we could talk for hours, and I see the tense or the huge interest of the attendees on this topic. Please feel free to share your thoughts with us. Please feel free to say, this is what I really, really need in order to make my job better. And this is what we as experts and we as professionals think we need as training, as lectures, as education to be better prepared for innovation. So if you allow me, I would close the session. Thank you very much. Mrs. Haifa, is it okay if I close the session now?
This is Taraya. Yes, you can close the session.
Okay, perfect. What I will do now, I will share my email address to everyone. So if you have any questions, feel free, please, to share them with me. If you have any questions for me or for Professor Jiu Lee, we can answer them. If you want court rulings we should share with you, we're happy to provide them, because I think you have a lot more you have a lot more questions than we could cover in this short time. Thank you very much for taking the time. Thank you very much for this very, very, very fruitful discussion. I loved it. Professor Dr. Jiu, I hope you enjoyed the session too. Any last words?
Oh, I just would like to thank you all for the attendance and for the very, very insightful question. I think I also learned a lot from the comments and the questions shared by our audience, and of course from Dr. Haideh today. And okay. I hope this is just the start of our dialogue about the role of the judiciary as drivers for innovation, and we will have this ongoing dialogue across jurisdictions for this. Thank you.
Okay, thank you very much for attending. It was amazing, your insights, especially very deep research. And again, we wanted to take the month of innovation in the UAE as a driver to kind of inspire you, to show you that it's possible, you as legal professions, to be a driver of innovation, to allow the right mindset for innovation, because you all will face these challenges and you all will be at the very forefront of these technologies. And we all have the responsibility to do our job best, which is to protect the people, right? To protect the people out there. That's why we're lawyers or legal professionals. Our job is to create kind of order, and that's why we need to understand the challenges which are coming towards us. And that's why we encourage you to have the innovative mindset. So for any questions, please reach out. My email address you can see here. Any questions to Professor Dr. Jiu, also welcome. And with this, I will end the session. Thank you very much. Have a beautiful day. Our next session at the Dubai Judicial Institute will be announced very soon, but we are happy to provide training and education for you all through the year. So we will see each other again, definitely. Thank you very much. Thank you very much, Dr.
شكرا جزيلا، يعطيك العافيه دكتوره. Thank you very much.